Good afternoon, everyone. Thanks for joining us for today's seminar hosted by HKIArb, and I'm Raymond Yang, today's moderator and also council member of the HKIArb. So it's our great honor to have the honor speaker, Dr. Jean Willems, to give us today's talk on the fair and equitable equal treatment under international investment agreement and under the International Covenant on Civil and Political Rights. Dr. Jane Willems, she's an associate professor with Tsinghua University School of Law. And apart from her academic achievements, she's also a very experienced practitioner in the field of international arbitration and both commercial arbitration and investment arbitration, which are most relevant to today's talk. Dr. Willems has served as arbitrator or chair in numerous international commercial arbitration involving ICC, CTAC, HKIAC, just to name a few examples. And she also served as counsel for the Law People's Democratic Republic in BIT-based investment arbitration proceedings. Last but not least, I have to say, Dr. Willems seems to be a linguist. She speaks 4 languages, English, French, Mandarin, Chinese, and also German. So without further ado, I shall hand over to Dr. Willems to give us today's talk. Thanks, Dr. Willems.
Thank you very much, Raymond, for your kind introduction. Good evening to each of you. Thank you very much for the Hong Kong Institute of Arbitrator for the kind invitation to give a talk tonight on some of the aspects of the substantive protections afforded in investor-state arbitration. So tonight, I would like to share in this talk some views on basically 3 topics. I'd like to review with you the FET, so the fair and equitable treatment that as it is invoked in investment arbitration, in particular through the treaty practice. What do treaties state and what do treaties provide they grant in terms of protections? How it's been invoked and the standard that has been required from claimants in order to meet and apply that treatment to the given facts. And finally, just a review on whether and to which extent some of the instruments of human rights law are occasionally invoked in investor-state arbitration with respect to fair and equitable treatment. So tonight I will share a few slides with you during the first part of this talk. Here is a chart showing to you basically the content of the most common clauses that we find in an international investment agreement. That means a state-to-state contract, an international treaty that is entered into states in the field of investment. That means to foster, to promote, and to protect international investments made by investors from reciprocal commitments made by investors towards investors of the other states. Of importance for tonight, I highlighted in red the relevant provisions. While the provisions, as you see, are composed of definitions which are pertaining often to jurisdiction matters, substantive rights, and in particular, one of the most frequent of the several standards of protection is fair and equitable treatment. It goes along with other standards of treatment, full protection and security, and specific standards of treatment like national treatment, the most favored nation clause, protection from expropriation, and sometimes the treaties do contain an umbrella clause. So those are the substantive protection, and we'll focus tonight on one of them that is regularly invoked by foreign investors against host states. But where are they invoked? What is the forum? What is the jurisdiction? It is contained, the jurisdiction is a clause that is contained in most of the modern BITs, and it is an investor state arbitration clause. So it provides for an ISDS regime, which is the investor is granted by an offer made to the host states, by the host states, to pursue a remedy of its rights by way of examination of whether there was a breach by international arbitrators. The BITs do provide for this type of arbitration agreements, and they give jurisdiction often through option clauses to either exit arbitration, the International Center for the Settlement of International Dispute at the World Bank, or for ad hoc arbitration under the UNCITRAL rules. Most frequently, these arbitration may be administered by arbitration centers, just like the HKIAC or the ICC or the Permanent Court of Arbitration. They may also provide for occasionally arbitration center institutional arbitration, such as the Stockholm Chamber of Commerce. So let's have a look at now one of the treatments, which is one of the protections that is granted independently from what the host state may provide as a treatment to its own nationals. So it is a treatment granted to aliens, that means to foreign investors. And we have two of them of those absolute treatment: full protection and security, and fair and equitable treatment. Fair and equitable treatment is one of the most invoked standard in investment arbitration. It is contained in most of the bilateral investment treaties, but as we will see, there is no uniform or unique form of the standard in the wording of the bilateral treaties. So we're going to first have a look about the concept that it may include, and then we'll move to the wording of the BITs. It's one of the most common guarantees, fair and equitable treatment, and it is common in fairly most of the bilateral investment treaty. It allows an independent review and an objective assessment by international arbitrators of a state behavior. The standard of FET is not determined by local law. It is determined by the terms of the treaty or by international law. It's difficult to determine its content, and some have said that actually it almost works as a gap filler that is left blank by other specific standards, like the duty not to discriminate and or access to justice that are specifically provided when they are in the bilateral treaties. It may, to some extent, because of the wording of fair and equitable treatment and its interpretation, have overlap with the principle of good faith, and we'll see whether and to what extent it may. It is historically not something new in the bilateral treaties that have been entered around the world since the 1960s and 70s. Out of the more than 2,800 bilateral investment treaties that we find, nothing new. This terminology pre-existed those BITs. As we see in treaty language, we find, for instance, in the Havana Charter of International Trade Organization of 1948, a reference to a just and equitable standard. In the Treaty of Friendships For example, if we look at the Treaty of Friendship between the USA and Germany of 1954, the term accord fair and equitable treatment to the national and companies of the other party and to their properties and interests was already provided for. It did exist at the time. The difference, so the wording was there. The wording is not new and has been reused, imported in the modern bits. What those treaties didn't have, and in particular, the Treaty of Friendship, is a right granted in those treaties to the investor to seek remedies directly against the host state. At the times, those treaties did not provide for a direct right of review of the treatment that claimed to have suffered against the host state. That direct right to sue the host state was granted through the modern bits, whereby under international arbitration, they were authorized, foreign investors were authorized and had a right of action directly against the states for potential breach of treaty. Let's look now at the wording of some of the FET clauses. Because I'm French, I thought I would introduce you to a treaty that's never been, to my knowledge, enforced, never been invoked. It is the French-Chinese Treaty, and we have here a translation in English of that treaty. It is in French and in Chinese, and Article 3.1 of the first generation of treaty. We are like 2 years after the PRC commenced a treaty program, and what that treaty was provided already for a protection under FET. The wording was the following: each contracting states, that means China and France, commits to ensure to investment made by the investor of the other contracting party a fair and equitable treatment. Plain language. Well, when we see that the treaty has been renegotiated in 2007, the wording changed, and the wording changed to will ensure a fair and equitable treatment in accordance with the general recognized principle of international law. And one of the questions there are two types of questions. What is the content of fair and equitable treatment? What does it encompass? And what does it mean when there is a reference to international law or to international principles of law? And that raises a question maybe of standard, that of standard to review the behavior of a host state. This is not something specific to this treaty or to the negotiations between those parties. There are quite, and we'll see in the coming slides, quite different wording, a diversity of wording in qualifying the fair and equitable treatment. For example, if we look at the 2012 Canada-China bid Article 4, we see first that each party shall accord fair and equitable treatment in accordance with international, that's 4.1. And then we have a standard that is provided. 4.2 provides that the concept of FET do not require a treatment in addition to or beyond what is required by the international law minimum standard of treatment of alien, as evidenced by general state practice accepted as law. So here we have a reference to, we have an application, a determination of FET in accordance with international law with a standard of treatment that does not require to go beyond a certain standard in international law, MST, minimum standard of treatment of alien. If I look at the next slide, we have two important treaties. We have, and we see the US treaty practice that may have, to some extent, has influenced Canada and may have influenced the negotiation and the wording of that treaty. When we look at the 2012 model bit, it does describe FET, but it adds that for greater certainty, paragraph 1 prescribes that customary international law minimum standard of treatment of alien as the minimum standard is to be afforded by the covered instrument. So specific reference to a norm of international law, customary international MST, and a standard. It does not require treatment in addition to or beyond what is required by that standard. And an illustrative list. Fair and equitable treatment includes obligation not to deny justice in criminal, civil, or administrative proceedings in accordance with due process as embodied in the principal legal system of the world. So we have a definition, we have a standard, and we have examples. The NAFTA treaty, the wording is the same in the new treaty between the United States, Canada, and Mexico, treatment in accordance with with international law, including fair and equitable treatment. But the NAFTA treaty does provide for a commission of interpretation, and early when the question was raised as to what is the standard of treatment FET under international law, a decision was rendered that is binding as an interpretation as applicable law for the interpretation of FET, and the standard that was prescribed was that it did not require, again, a treatment in addition or beyond the standard of international law for the treatment of aliens. So here we have a reference. We either have bits that provide for a plain provision of FET, or we have qualification or reference to international law and customary international law. The EU treaty practice is quite interesting because the EU treaties that have been negotiated at the level of the EU with either Vietnam or with either the Canada or with Singapore do provide for another type of definition. It's still anchored in international law, but what is interesting is that it provides for an illustrative list, which includes the standard. So therefore, we have denial of justice as A in criminal, civil, or administrative procedures. So that's close to the illustrative list that we have under the model bid 2012 US model bid. But then it provides for breach of due process with a threshold, fundamental breach, or arbitrariness with a threshold that is manifest, or targeted discrimination based on race or religious belief, or abusive treatment, etc. So we have here illustratively containing some qualifying thresholds as to what should be considered as a breach under international investment law for the purpose of this treaty. So we've reviewed treaty practice, very diverse wording, different standard, although the content may be the same, due process, denial of justice. But the question is, how are the arbitrators who are requested to enforce, to review the state behavior, going to test these treatments and implement these provisions? As we know, bilateral investment treaty as international investment agreements are not subject to domestic law for the purpose of their interpretation. They're subject to general rules of interpretation that have been codified in the Vienna Convention on the Law of Treaties. And one of those rules, the general rule of interpretation of the VCLT, the Vienna Convention on the Law of Treaties, Article 31 and 32, the general rule in 31 provides, that's all, it's very familiar, very well-known rule. A treaty shall be interpreted in good faith, in accordance to the ordinary meaning be given to the terms of the treaty, in their context and in view of the object and purpose of the treaty. So ordinary meaning, in the context, and in view of the object and purpose of the treaty. And this is what the task that arbitral tribunal had to take. It is to review and to interpret these provisions when they were invoked by investors. Many of these decisions actually concern exit arbitration, non-exit arbitration, the NAFTA treaty with a qualified provision, or non-NAFTA treaty. So we're going to review some of them to have a roadmap on what is nowadays a concern. Is there consistency? Is there content in the interpretation of what the scope of FET standard provides for in terms of protections? And here, the idea is if we have a provision, the interpretation should be as straightforward as possible and consonant with the object and purpose of the treaty. That means the primary goal of investment treaty is to create a favorable environment for investment. That means reduce the political risk. And that's what was decided in MTV versus Child. And the arbitrators found that fair and equitable treatment should be understood to be a treatment with an even-handed and a just manner that would help conducive to fostering the promotion of foreign investment. So there is a purposive approach. The purpose of the treaty is to foster and promote foreign investment. But at the same time, when we look at the orderly meaning of the words fair and the words equitable, we look at the dictionary and we look at the orderly meaning, which would be just, even-handed, unbiased, legitimate. So we have the tension between those two, and how it is implemented is, let's have an illustrative list. If we look, and it's often the case, at the context of the review of fair and equitable treatment in the regulatory framework, that means when the executive branch of the government's action is being reviewed by the arbitrator, is to check whether there was a change, there was an alteration between the regulatory framework that was available at the time where the investment made the investment and relied upon that regulatory framework to invest, and later where there was a change that altered the expectations, or that alters substantially the conditions upon which the investor had made its investment. We have a few cases that are now classical cases. CME versus Czech Republic in 2001, the arbitrators found that for a TV station, the host state legislative and regulatory changes had ignored the rules governing the investment business, and the FET obligation that the state had been eviscerated by the arrangement that was made, by eviscerating all the arrangement that the investor had made and in reliance upon which it had invested in the country. So we take the moment, the time of investment, the importance of whether there what was the context, the regulatory context, and we take the change that were made between the original time and the time the treatment may have been breached. The behavior of the states is based also and is reviewed also on what the investor relied upon and what were the legitimate expectations of the investor at the time the investment was made. That's an important component. It may not be worded as such in the term of the treaties at the time, but it is added sometimes in the list of the elements of composing the treaty in the most recent treaty. The legitimate expectation of the investor, that means the inconsistency of the conduct of the host state is one of the elements that will trigger the responsibility or a breach of that treatment. One of the elements is therefore for the investor to indicate what was the expectation and whether any expectation could be relied on. That means what were the commitments that were made to that investor by the state at the time it made the investment. That is often a matter for the investor of burden of proof to prove that it could rely on legitimate expectations, because indeed commitments were made directly to that investor at the time it made the investment. The standard is objective and it's repeated by arbitrators. It is not about reviewing whether the change of the regulatory system is made in good faith or in bad faith. Liability may be incurred irrespective of the intention of the host state. Now, let's look at some of the interpretation and what would the word fair and equitable treatment mean. When we have a reference to international law, when we have a reference to customary international and the minimum standard of treatment of alien, that rings a bell for the arbitrator. It is the framework under which alien must be treated under this standard of minimum standard. And before the treaties were written, there were cases. There is a line of cases, and there is in particular prior decisions that have reviewed standards of minimum standards of treatment of alien, either in court or not in court. And that standard has been defined, has been determined in earlier cases. One of the cases of reference is a 1926 decision rendered by the Mexico-US Commission that was set up in 1921. And one of the famous cases is the Nair case. According to the opinion that was rendered, and it's a 3-page opinion, the arbitrators, the members of the commission, define a high degree of wrongfulness in order to trigger the liability of the states under the minimum standards of treatment. In other words, the liability threshold, if there is a reference to the MST, seems to be raised, which if the standard for breach of liability is raised, therefore it means that the protection of afforded to the investors is a lower protection, because the burden to prove and the standard to prove the breach has reached a higher standard. What is that standard? Well, let's first look at just a slide to remind everyone. Customary international has 2 components, and it results from a consistent practice of the states as they follow from a sense of legal obligation. Now, minimum standards of treatment is a norm of customary international which governs the treatment of alien by providing to the alien a minimum standard regardless of what the host state is providing as protection to its own citizen. It is a standard that is independent from domestic law, and that is afforded in order to protect aliens, either physical person, foreign nationals, or the properties of the foreign nationals. It often is understood as a broad concept. It includes a doctrine of denial of justice and other matters of law and responsibility. Under the treaty protection practice prior to the BITS, that required nationality of an alien, and that included cooperation, and that required the exhaustion of local remedies in the host states. And thereafter, the home state would decide or not to endorse the claim and to trigger state-to-state dispute at the level of diplomatic protection and raise come to the defense of the interest of that alien. And this is in that context that administration of justice, treatment of aliens under detention, or full protection of security were reviewed through these state-to-state disputes. The most cited source or expression of minimum standard of treatment is that decision Nair of 2026, where the standard for denial of justice was determined by, in that case. That case opposed the United States versus Mexico after Mr. Nair. So it was his daughter and his wife who raised the damages because after the murder of Mr. Nair by attackants, he was murdered by a group of armed persons in Mexico. And what was claimed by the claimants was that by the victims, the heirs of the family, is that there had been no investigations or no proper investigation in the death of their Mr. Nair. So the question was to review the behavior of the states and the state administration. And in that case, there was a wording that is set forth some standard. It stated that the treatment of an alien, in order to constitute an international delinquency, should amount to an outrage, to bad faith, to willful neglect of duty, or to an insufficiency of governmental action so far short of international standard that every reasonable and impartial man would readily recognize its efficiency. So it's an opinion of the Commission. But what's interesting is that that isolated opinion of the Commission and that standard that was afforded as an outrage to bad faith was actually repeatedly referred to in investor state arbitral award. That decision of 1926 is one of the most cited precedent on denial of justice and applied in the context of fair and equitable treatment when it is coupled with a minimum standard of treatment in international law. And I've listed here, we have some of the cases, the classical cases that have referred to it, in particular, cases that have been rendered in application of the FET provision under the NAFTA treaty. So there is a continued vitality and an evolution of the Nair standard of treatment, and that whether it is still good law, whether it is still relevant, whether that test should apply still 100 years later, has been questioned and has been discussed both by the arbitrators, by counsel, of course, representing the parties, and by commentators. And one of the questions that is put is, should we rely on that test? Should we rely on the threshold that was provided in 1926, or has the law evolved since 1920? And judges, arbitrators have decided in different views. If we take one example in the Monde versus USA 2002, in that investment arbitration case, it was an exit additional facility case. It was stated by the arbitrators, and the arbitrators were Sir Stephen, Professor Crawford, and Judge Stephen Schwebel, that in the modern eye, what is unfair or inequitable needs not to equate outrageous or egregious. In particular, a state may treat a foreign investment unfairly and inequitably without necessarily acting in bad faith. And they added that the content of the minimum standard today cannot be limited to customary international as it was recognized in arbitral decision in the 1920s by those mixed commission. So we have different standards. I just said, even though decisions, even though the standard was not to go beyond what is recognized as the minimum standard, the cases have taken different views. Some cases have applied the high standard threshold, and they have decided, yes, we're applying the Nair test. Shocking, egregious violation. That has been applied, for example, Ganesh versus USA in 2000. Some arbitral tribunal have gone beyond, below that standards, and they have lowered the standard to discriminatory or exposing claimant to racial prejudice. So the discrimination tested at a racial discrimination or a complete lack of transparency. But even some tribunals, Merrill versus Enring versus Canada 2010, have disregarded the Nair test and have also disregarded the interpretation of the under the NAFTA treaty of the Commission, and they have stated that fair and equitable treatment means any act or behavior that may infringe a sense of fairness, equity, reasonableness. So quite a diversity in the application on the standards, making it difficult and maybe unpredictable to determine the outcome of whether there exists, what is the standard of the liability, and whether there is a breach. So that being said, we have therefore a first set of decisions that are not helping us very much to determine what is FET and how, when it is breached. Council are very creative. Council have tried to import into the standard, have tried to import investors, protections, and tried to import some norms, occasionally based on human rights law that has developed in the 20th century, mostly through international instruments, covenants, or regional covenants on those rights, and import them and see to what extent they could provide content or standard for the determination of the state behavior. Those human rights norms may influence the meaning. They may be used as components of the meaning of the bilateral investment treaty, and in particular FET and full protection and security, by identifying that minimum standard. Is it still there or has it moved? Some obstacles have been raised, and arbitrators have not always welcomed the attempts or these use of human rights law into international investment law. Questions to overcome pertain to the jurisdiction of the arbitrators and the scope, the subject matter scope of the jurisdiction. Other questions pertain to the norms applicable. What is the law applicable to international investment dispute? Let's review some of the decision again. A decision here with Judge Schwebel, Professor Don Wallace, and Mr. Ron Rollet. This is a Balloon versus Marine Drive Complex versus Ghana. It's an award on jurisdiction and liability. It's an ad hoc arbitral tribunal. 1989, one of the first tribunal that were faced with a violation of different violation for expropriation, denial of justice, and violation of human rights. In this case, Mr. Balloon and his company alleged that a respondent had interfered with his investment, and by various means, including the arrest of Mr. Balloon and his deportation from Ghana, Africa, the respondent effectively expropriated the asset. So expropriation, denial of justice, and violation of human rights. In that case, the arbitrators recognized that customary international law, and they recognize the content of customary international law, and they recognize also the fact that fundamental human rights, in the view of that tribunal, included property as well as personal right. One of the elements of the applicability of human rights is whether those rights pertain to personal rights of the individuals, or whether they pertain and they include economic rights and property rights. And the arbitrators said they did, but however, the issue before the tribunal was said is that the scope of the arbitration agreement, the investor-state arbitration agreement, was limited to a commercial dispute. In this case, the dispute arose out of a contract that was entered into in the context of the Ghana's investment code, and the investment code provided for protection under arbitration. The government agreed to arbitrate, that was the offer pending, only disputes in respect of the investment, the foreign investment. Therefore, other matters such as the claim for wrongful act, where the claim or wrongful adage act, that is the violation of human rights of Mr. Biloon, may be relevant for the consideration of the investment dispute, but they're beyond the jurisdiction of the arbitrators, and they cannot give rise to an independent cause of action based on human rights. It has to be a violation of the bilateral investment, of the duties under the International Investment Code, and that was beyond the scope of investment duty. It is not the only tribunal that has refused to review this. In here, the Netherlands-Romania bid, the arbitrators, now was an exit decision in their final award of 6 May 2013, noted that the claim had alleged breach of FET, full protection and security, and protection against unreasonable discriminatory measures. And here what was at stake was a violation of the European Convention on Human Rights. And here the arbitrators again said that the legal dispute must arrive directly out of an investment. And even though Romania may be a member of that convention, that regional European Convention, it had its own system, it has its own court, and its own institutional structure for complaints for breach against the state party. So here again, the arbitrators decided they had no jurisdiction, they were not competent to decide issue on the applicability on the application of the ECT. They said that the governing law on this issue should be found in the BIT itself. And interestingly enough, they added that actually what was alleged as a breach of the European Convention on Human Rights pertained to individuals. Well, in this arbitration, there were only companies. So the breaches dealt with non-disputing party in this arbitration. So the alleged breach was also in terms of personal jurisdiction. It was beyond the scope of the arbitral tribunal. Now, the International Covenant on Civil and Political Rights that came into force in 1976 has been raised on 2 occasions by claimants. Article 14 provides for fair trial, fair and public hearing, and there is a long article, and different sections of that Article 14 have been raised. Have been raised by arbitrators. So have been raised by investors, and whereby investors have attempted to incorporate that norm, that provision into the dispute. Different ways, different legal technique to try to incorporate it. First of all, if we look at the Toto versus Lebanon case rendered, the final award rendered by ICCID, one of the elements that was raised is that Lebanon was a contracting party to the International Covenant. So by way of it had an international obligation to apply 14.1. That was what was raised. What was behind that was not so much the application of 14.1, but the application of the case law that had been rendered by the Commission of the ICCPR that is set up in the protocol of the International Covenant. And actually, Lebanon is not a party to that protocol. So it was a party to the convention, to the covenant, but it was not a party. It's not ratified the protocol, so it could not be summoned to the commission, and therefore the decision of the summon, they may be, however, relevant for the interpretation of 14, but the arbitrators decided that in terms of, so there was an obligation. Now the problem in the other case that was raised is a more interesting case because it has different dimension. The Alwaraq Indonesia case of 1914 is a UNCITRAL arbitral award. And in that, the agreement, the multilateral agreement that was entered into, the IOC agreement by the Organization of Islamic Conference Investment Agreement, did not contain an FET clause. It contained a provision 10.1, that provided for a duty not to affect the ownership of the investor's capital or investment by depriving him of its basic right or the exercise of its authority on the ownership, possession, or utilization of its capital. The question that arose was, what is the meaning of basic right? And there was an allegation, there was an attempt by the claimant to interpret basic right as basic fundamental human rights based on Article 14. In that case, the investor in Indonesia had been condemned without being present and did not have a right to appeal. And that dealt with criminal proceedings. The tribunal refused to apply the ICCPR to the interpretation of the word basic rights. It decided that the purpose of the interpretation of a treaty should be made under Article 13.1, and the object and purpose of the agreement being investment promotion and protection by conferring a broad range of rights to the investor. But considered as a whole, he thought that the basic rights are here in the wording of 10.1, relying on or directly connected to the ownership, the possession, or the use of the investor's capital, and properly those basic rights do not lead to a general reference to political rights or civil rights as those that are contemplated under Article 14 of the ICCPR. Therefore, it denied the right that there was a guarantee of the right in the terms of the fair trial, in the terms of Article 14. Now, what was interesting, and is the second dimension of that case, is that Indonesia was a party to the ICCPR, and as a term of applicable law, the courts here decided, the arbitrators decided that it was part now of general international law, and it's an extension of the rule first established by the Permanent Court of Arbitration in 1925, that rights under international law should be conferred to an individual. And it says that this convention is a universal instrument, and it contains binding legal obligations to the states parties to it. And in this case, Indonesia was party to the convention. Now, what was interesting is that it's the final layer of this case, is that there was no FET clause. The FET clause was incorporated, was imported into the dispute by way of the MFN clause. And the MFN clause, Indonesia had entered into a treaty with the UK that contained an FET clause, and for the purpose of interpreting the FET clause that provided for fair and equitable treatment, the tribunal found that the claimant's rights were guaranteed by the FET, guaranteed by the ICCPR to which Indonesia is a contracting party did form an element of the FET with regard to the fair trial. And by applying the covenant, the international covenant, as a mean of interpretation of the content of the FET standard, it included that standard, that component of denial of justice into the review of the state behavior. And it found that the claimant had not received FET treatment as enshrined in the international covenant because it was not present at the trial, it could not appeal, it did not receive notice of the decision. So one decision, interesting decision, 2014. So we have to see whether other arbitrators will be faced with attempts to incorporate or to interpret the FET standard in the context of those international conventions. Finally, just one observation. The FET standard is often not raised alone. Let's keep in mind that in investor-state arbitration, the investor is picking several, is invoking several standards. Most of the time, it will invoke FET, but not only fair and equitable treatment, full protection and security, and indirect expropriation. So it will look at the behavior of the state, look at 1, 2, or 3 actions taken by the states, and will apply to these actions the review of fair and equitable treatment, a review under full protection and security, and a review on indirect expropriation. So these are often, this is often coupled with, so it's the most reviewed standard, it's the most discussed standard, but it's not the only one. It's often looked at, well, that's the catch-all provision, that's the gap filler. When it's not another breach in the contract, we will look at this one. What we have seen is that the covenant has been reviewed under Article 14, which is the denial of justice. So it's really a narrow area of what is reviewed. It's often judicial, the judicial branch, when most of the behaviors are reviewed under that behavior of the states is actually the executive branch, the regulatory system. So this concludes this talk. And I thank you again for the kind invitation, and I'm available for questions, if any. Thank you very much.
Thanks for Dr. Willems' informative and instructive talk. I think everyone from the audience have learned something from today's talk. So has anyone got questions want to ask Dr. Willems? This is a good opportunity. If anyone has questions, you may type your question in the Q&A box, and Dr. Willems will take question from there. Pending questions from the audience, probably I have a question for to my knowledge, Dr. Willems, I mean, in some of those investment contracts, there are stabilization clause. And as you mentioned during the talk, the stability of the legal and business framework is an essential element of fair and equitable treatment. So maybe you can shed some light on the practice of stabilization clause in investment agreement and the requirement, the minimum requirement of stability of the legal and the business framework. So how will the tribunal see this kind of interaction between the two elements? Thanks.
Thank you for your question. Stabilization clauses or negotiated clauses, they only exist if the investment is covered by an investment contract that is entered between the foreign investor and the host state. So in state contracts, in international contracts, for example, international concessions, whereby a foreign investor will enter into a contract with the host states for the purpose of an oil and gas concessions, for example, one of the dangers is that the contracting party is both as a double hat. It is the regulator and it is also a party. If the applicable law chosen by the parties is the law of the host state, which is most often the case, it is sometimes the case because it's mandatory that the host state law does apply, then in that case, those stabilization clauses guarantee, and often it is the tax regime, often guarantee to the foreign investor, because he has requested so, that the legal framework will not change after the time the contract has been entered into. Otherwise, the state will have the prerogative by changing the law to change the balance of the contract. But this is a matter of contract dispute. That is not a matter of treaty disputes. Those stabilization clauses do exist only if the investment is covered by a contract, and what if a dispute arises under that contract, the arbitrators will review whether there was, what is the applicable law, and whether there has been a change in the regulatory system. But it applies as a scope of the arbitration of the applicable law. In the framework, the change of the framework of the legal framework under the FET standards is not in the context of a contract. It is in the context of an international obligation under a treaty, and that international obligation applies regardless of the existence of a contract or not. And the arbitrators under the treaty dispute will review whether, one, there were commitments made that this would not, that the legal framework or the regulatory framework would not change. Usually it is a declaration or it is a letter from the administration sent to the investor at the time he makes the investment, and whether the alteration deprives essentially the investor from its the enjoyment of or the ownership of its assets. Now, there is a debate, and it's to your question is interesting because it raises the debate of the powers of the states to regulate certain activities. But that goes beyond your question, but I wanted to answer these questions. There is a question from Damien. You mentioned that in considering the FET compliance, which is itself is an objective test, a tribunal will consider the legitimate of the investor, presumably is analyzed from a subjective perspective. Yeah, it is a commitment. It is the existence, absolutely. It is the existence of a commitment made by the states, and the arbitral tribunal will read and interpret whether, from the reading of the commitment that was made, one of the issues that that commitment may have been made verbally, but if made in writing, whether that would have reasonably created legitimate expectations and commitment upon which the investor relied. There may be many commitments made by a state. There may be many declarations. What's important is what are the decisive ones and whether the investor relied upon them. So that is a matter of burden of proof.
And thanks, Dr. Williams. I think we have got another question from Polo Falling. So the question is, actually the question is related to another general standard, the FPS, full protection and security. So the question is, could the full protection and security standard be regarded as part of the broad FET standard? And these FPS standard originally developed separately or as a part of the FET standard? So there are actually two questions. Okay.
Thank you for your question, Paolo. This is a very interesting question. Full protection and security originally spoke about the threat, the physical threat that aliens may suffer abroad, and that the threats or the destruction of their properties. So we're speaking here about the physical protection and security of an investor or the property of an investor. The idea of the minimum standard that was developed was that an alien may be targeted as such in a given jurisdiction, and he should be afforded protection at a minimum standard by the home state, failing which by the host state, failing which his national state would actually be able to bring a claim and seek compensation. The term has evolved on full protection in security, especially after some cases like the WINA versus Egypt case, where the concept of full protection and security has enlarged to include the legal protection and security. So being the stability of a legal framework. And indeed, there are connections at some point between for the review of the regulatory system and the legislative system. There can be interconnections between the full protection, the legal full protection of the investor or foreign corporations or their investment, and the stability of that system. Yes, there is an interconnection, but there is treaty practice too. Having said that, we see that in the most recent treaties, the states have reworded and made elements to clarify the standard of full protection and security by indicating that this does not extend to legal protection, to the legal framework. It's limited to the physical protection.
We have a follow-up question from Grace. So actually, I mean, the question is related to the stabilization again, the legitimate expectation of the investor. So her question is, in case the investor raise a claim based on a substantial alteration of regulatory framework on which the investor relied to bring a claim against the host state. So what are the possible or potential defense which the host state may put forward to defend its case? So this is a quite broad question. Maybe Dr. Williams just maybe give a few examples which I mean, there are a number of investor host state dispute investment arbitration, and these kind of issues have been argued by the parties. Maybe, I mean, you can just give us a few examples which the host states have argued and maybe win the favor from the tribunal. Yeah.
Well, this is a very interesting question. Thank you, Grace, and thank you for raising that question. This is the question of balancing rights, the right of the legitimate expectation of the investor versus the right of the state to regulate and to change, actually, its regulatory framework. the idea behind that is that the states must regulate for the interest for their own interest and the interest of their citizens, and therefore the regulatory framework may change. This is one of the elements of defense that are raised by the states, especially for tax purposes, for health purposes, for fundamental rights. It has been raised successfully by host states as a policy power in order to be able to regulate these new issues. Now, those defenses have been successfully raised, especially when they. So there are some cases. If we take, for example, the Philip Morris versus Uruguay cases, we have seen that the state in the exit case, under that case, the Uruguay raised the possibility to regulate health issue matter from a state perspective, and that it could ban advertisements of cigarettes. So that would infringe the rights of the enjoyment of the rights of the investor. So here, the tobacco company was given a legal framework, regulatory framework upon which it relied to promote and commercialize its brand. That changed, and in this case, it was held that the state had the power to regulate and change its regulatory framework. So there are instances, actually, just to conclude, human rights are raised by states. Human rights are raised by states in order to pursue goals, in order to change their framework. Green law, decisions, regulatory laws, change of the legal framework in order to pursue environmental or health matters which are considered by human rights, do access to water and others, do constitute basic elementary principles of human rights that the states do rise as a defense against the investors' expectations.
Okay, thanks, Dr. Willems. I think we have maybe the chance for last question, no question. Okay, actually, I mean, just maybe do you want to take one more question, Dr. Willems?
Yeah, I'm happy. I'll take Grace's question, because as a source of law, there are different types of and that's just a follow-up question. I think Grace was saying many human rights are not absolute. There are limitations. Our ICCPR only relate to the interpretation. No, our ICCPR and other human rights treaty only relate to the interpretation of FET. Today's talk is about FET. We may discuss other rights, but what's important is that some covenant, some international instrument have a limited goal. They address limited issue. Some international instruments have a general goal. One of the questions that has been raised in investment arbitration is that application of general law, international law, to specific areas of international law, which is international investment law. Some of these treaties may apply to investment arbitration, because they may include the economic rights of an individual. So that's one component in order to, they may be relevant to investor disputes regulation. Others are relevant to, and that's what it's difficult to find an angle, because most of them are relevant to different types of or matters that do not arise in investment arbitration. Therefore, there are few cases One of the case that was here was that there was a contracting party to the respondent was a contracting party to that convention. That convention or that international covenant was large enough to encompass economic rights, and it provided for a subject matter that had to do with the content of fair and equitable treatment in courts. And that was, in that case, that was a criminal proceedings. So you see, it is difficult to find an angle to sustain the invocation of those covenants by an international investor. So with that, I think I can't go anymore, because that would open all the doors, which is the use of and the reliance of states as to human rights, environmental rights, rights to water, health rights, in order to support their defense against the claims made by host states. So that's another chapter.
Thanks, Dr. Willems. I think now, I mean, we have run out our time, so we have to call it an end for today's session. So thanks for Dr. Willems again. And I also noticed that Dr. Willems has authored quite interesting articles and books. For example, investment dispute and China's bids, BITS, jurisdiction with Chinese cultures, and also other relevant articles and books about Chinese related arbitration. So we will touch base with Dr. Willems to see whether she would like to give us more talks on Chinese related investment arbitration or commercial arbitration in the future. Thanks.
Thank you very much for the kind invitation. A very good evening to all of you in Hong Kong, and look forward to seeing you live soon. Good night.